Howard Lutnick is the proposed Secretary of Commerce to be appointed by President Donald Trump. He is a billionaire inventor with over 400 U.S. patents to his name and 800 total. On February 5th, 2025, he cleared his first Senate committee meeting by 16 to 12 votes. So he goes before the full Senate and will likely be confirmed as the next Secretary of Commerce. The Secretary of Commerce is particularly relevant for patent practitioners and stakeholders because they oversee the U.S. Patent and Trademark Office. Even more so is future Secretary Lutnick's extensive experience, not just in prosecuting patents, but in litigating them as well and monetizing them. You can look a little bit to the priorities of the past two U.S. Patent and Trademark Office directors to see what you can expect from future Secretary Lutnick. Andrei Iancu was President Donald Trump's first appointee to the U.S. Patent and Trademark Office as director. He prioritized patent owner rights and sought to limit what he considered perhaps an overly aggressive invalidation system by the Patent, Trademark, and Appeal Board. President Biden's appointee, Kathy Vidal, prioritized patent validity to a higher level, so she actually took steps procedurally to embolden the Patent Trial and Appeal Board to ferret out what she believed would be invalid patents for the protection of others against frivolous claims of infringement. So there are two legislative bills that future Secretary Lutnick is surely to be considering supporting. Senate Bill 220 relates to limiting and realigning the priorities of the Patent Trial and Appeal Board. And for many patent owners, this is very important because the very organization that grants their patent, which is presumed valid by a clear and convincing standard, also turns around later in litigation and invalidates the very patent that the same organization granted. The other bill that's being proposed is Senate Bill 2140, which relates to patent eligibility. And from the dot-com days, there was quite a bit of litigation of these assets, which were typically software related or business method related. And in response, in a 2014 decision, Alice v. CLS Bank, the Supreme Court put its foot down and limited what they would consider eligible as a technological improvement versus just a mere abstract idea. That's created a lot of uncertainty. So the Senate Bill 2140 seeks to clarify that anything man-made, not naturally occurring, would be patent eligible. For Lutnick, some of these issues are quite personal because he's such a prolific inventor. Even on the Alice CLS decision on patent eligibility, he's had cases where he's appealed and lost on the appeal on patent eligibility. So going back to Senate Bill 2140, he's more likely to be supporting that bill simply because there's so much ambiguity right now into what is patentable and what is not patentable. The other thing that Lutnick had discussed before the Senate committee is the growing backlog of cases before the U.S. Patent and Trademark Office. On the patent side, we're looking at over 20 months before first examination of a filed patent application. On the trademark side, we've traditionally had trademark examining attorneys get to those cases within 2.5 months, as it's currently now over 8 months pending before a trademark applicant knows whether it would be approved and can continue to advance in the process. So the takeaways of Howard Lutnick as potential Secretary of Commerce would be you would likely see a greater support for financial technology and software. He would certainly support legislation that would clarify the rights to these types of technologies. Crypto patent filings, you would likely see, not just on the intellectual property side, but on the regulatory side, more embrace and support for these financial vehicles. Stronger rights for patent owners. So I think you're going to see a little bit more like Director Iancu He's going to prioritize the fact that we're going to preserve patent validity when we can, and only in the worst cases have the same agency come down and reverse their own work. And we'll probably see a higher market for patents and licensing because the presumption of validity without the PTAB looming in with a 70% invalidation rate is going to give licensees and purchasers of these patents greater confidence that they're getting something for their money.